Legal and Privacy Brief for July 18, 2026. Flock Safety ends rollout of audio surveillance that would have listened for screams in public spaces. Texas AG Ken Paxton faces accusations of voting from an address where he no longer lives while prosecuting voter fraud cases. The FCC eliminates transparency requirements for ISP fees and pricing. Fitton settles video privacy class action for $2.5 million. Fairlife Dairy suspends U.S. production after ransomware attack. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief, July 18, 2026. Next section, Privacy Developments. Flock Safety cancels distress detection audio surveillance. Flock Safety reversed its plan to deploy microphones that listen for human screams through its acoustic gunshot detection devices. The company announced the cancellation after EFF and Privacy advocates raised concerns about the civil liberties implications, potential illegal eavesdropping under state wiretap laws, and risks of armed police responding to ordinary loud interactions. The underlying gunshot detection system remains active and continues to listen for community disruption, including nonviolent events like car sideshows and fireworks. The Chicago system has triggered police shootings at children lighting fireworks. Flock's license plate reader network continues to expand despite similar mission creep concerns. Compliance action. Review any municipal contracts with Flock Safety or similar acoustic surveillance vendors. Verify that local wiretap laws permit continuous audio monitoring in public spaces. Document what non-gunshot sounds trigger law enforcement response. Source, EFF Deep Links. $2.5 M. Fitton video privacy settlement. Fitton reached a $2.5 million class action settlement over allegations the fitness app shared user video data without proper consent. Consumers who used Fitton during the class period may qualify for payments. The settlement addresses claims that the app disclosed personal data to third parties in violation of video privacy laws. Settlement terms require Fitton to update disclosure practices and data sharing policies. Source, top class actions. TikTok child privacy investigation, class action investigation underway for parents whose children created TikTok accounts before age 13. The lawsuit alleges TikTok collected personal data from underage users in violation of COPPA and state privacy laws. The investigation focuses on data collection practices, parental notice failures, and retention of children's information after account deletion. Parents may qualify if their child had a TikTok account before turning 13. Compliance action. If operating apps with users under 13, audit COPPA compliance including age verification mechanisms, parental consent workflows, and data minimization practices. Review data retention policies for deleted minor accounts. Source, top class actions. Next section, Litigation Updates. Texas AG Paxton accused of voter fraud while prosecuting others. Case investigation pending. Texas Attorney General Ken Paxton, who created a voter fraud tip line in February and vowed to stop at nothing to prevent illegal voting, is accused of voting from an address where he has not lived for 2 years. Paxton's wife stated in a 2025 divorce filing that he moved out of their Collin County home a year earlier. Yet Paxton continues to list that address on his voter registration and voted there in 6 elections, including the May 2026 Senate runoff. 3 election lawyers told ProPublica and the Texas Tribune that Paxton may have violated Texas election law, which requires voters to register using their actual residence address. Voting while ineligible is a second-degree felony punishable by up to 20 years in prison and $10,000 fine. Paxton's campaign did not address the allegations, but called the reporting baseless and lie-filled without identifying specific inaccuracies. Prosecutors rarely bring residency cases because they are difficult to prove, requiring consideration of multiple factors under Texas case law. Source, TechDirt. Match, Com Hidden Paywall Class Action Case No. 1-26 CV 5554 S. D. N. Y. Joseph Quitano filed a class action against Match. Com alleging the dating service falsely advertises its highlights feature as included in subscription packages when it requires purchasing additional Super Likes add-ons. The complaint alleges Match does not disclose the paywall until after consumers purchase subscriptions. Quitano claims he signed up for a platinum membership in June 2026, believing he could contact any member, only discovering the restriction after payment. The lawsuit references a 2019 FTC. The Federal Trade Commission complaint alleging Match used fake profiles to induce subscription purchases and suggests Match may similarly use fake highlights to sell super likes. The complaint asserts violations of New York general business law, breach of contract, and unjust enrichment. Quitano seeks to represent nationwide and New York subclasses of Match subscribers from June 2023 forward. In August 2025, the FTC settled with Match for $14 million over deceptive advertising and billing practices. Compliance action: review subscription service disclosures to ensure all feature limitations and additional purchase requirements are disclosed before payment. Audit marketing materials for claims that features are included when paywalls exist. Sources: top class actions. GM coolant leak class action, case no. 2-26 CV200 and 17 RWS, ND. GA. Jonathan Dixon filed a class action against General Motors, alleging certain Chevrolet, GMC, and Buick vehicles have a radiator hose quick connect defect that causes coolant leaks, engine overheating, and catastrophic engine damage. The complaint alleges the defect affects 2023 to 2026 Chevrolet Colorado and GMC Canyon with L3B2. 7L engines, 2024 to 2026 Chevrolet Traverse and GMC Acadia, and 2025 to 2026 Buick Enclave with LK02. 5L engines. Dixon claims he purchased a 2024 Chevrolet Colorado in March 2024 and experienced the defect in February 2026, paying $489.36 out of pocket because GM's warranty did not cover the repairs. The lawsuit alleges GM knew about the defect before selling the vehicles but failed to warn consumers or provide adequate remedy. Claims include breach of warranty, concealment of product defects, and violations of federal warranty law and Georgia consumer protection laws. Source: top class actions. Lume unscented deodorant class action, case no. 1-26 CV5309 SD NY. Shelby Cooper and Jeffrey Leigerman filed a class action against Lume deodorant, alleging the company falsely labels products as unscented, despite containing fragrance ingredient floral pyranol. The complaint alleges consumers seeking fragrance-free products for health or allergy reasons were misled by front-label unscented claims, while the ingredient list buried the fragrance component. The lawsuit asserts violations of California's Unfair Competition Law, False Advertising Law, and Consumers Legal Remedies Act, plus breach of warranties and fraud. Plaintiffs seek to represent nationwide purchasers of Lume's unscented deodorants during the 4 years preceding the June 24, 2026 filing. The complaint alleges Lume capitalized on growing demand for fragrance-free hygiene products driven by ingredient safety concerns and skin sensitivities. Source: top class actions. Next section: regulatory guidance. FCC eliminates ISP fee transparency requirements. The FCC will vote to eliminate rules requiring internet service providers to list pass-through fees on broadband nutrition labels and may make the labels themselves harder for consumers to find. The transparency requirements, adopted in 2022 under the Infrastructure Bill's $42.5 billion broadband subsidy program, mandated that ISPs disclose all fees, usage caps, and restrictions in standardized labels. Studies found most ISPs did not comply, and the FCC under Biden never meaningfully enforced the requirements. FCC Chairman Brendan Carr claims the rollback will provide clear, accurate, and concise information to consumers, despite removing the requirement to disclose fees. The nutrition label approach was congressionally mandated to ensure broadband subsidies resulted in quality service, but the Trump administration has stripped oversight while redirecting subsidies. Compliance action. ISPs should preserve documentation of fee structures and pricing disclosures in case the rule is reinstated or state attorneys general pursue deceptive pricing enforcement. Companies subject to state consumer protection laws may still face liability for undisclosed fees. Source: TechDirt. Next section: enforcement actions. RFK-Jr. Potential Hatch Act violations. Investigation requested. Senator Ron Wyden requested an investigation into HHS Secretary Robert F. Kennedy Jr. for potential Hatch Act violations after Kennedy reportedly contacted 2 Libertarian congressional candidates in Iowa, urging them to drop out to help Republican candidates. In a call to Marco Battaglia, Iowa 3rd District, Kennedy said, "If the seat flips, it'll make my life hell." In a call to Rick Stewart, Iowa 2nd District, Kennedy offered to help Stewart find a federal position outside elected office in exchange for suspending his campaign. The Hatch Act prohibits executive branch officials from engaging in partisan political activity. Wyden alleges Kennedy acted in his official cabinet capacity to manipulate close races where Libertarian candidates could pull votes from Republicans, helping the GOP maintain its House majority and making it easier for Kennedy to avoid Democratic committee subpoenas. Source: TechDirt. Fairlife Dairy ransomware attack halts U.S. production. Coca-Cola's Fairlife Dairy unit detected a ransomware intrusion on Thursday and suspended all U.S. production. The company filed a disclosure stating the full scope of the incident is unknown, but product quality and safety were not impacted, and Canadian operations continue. Fairlife operates plants in Michigan, New York, and Arizona and exceeded $1 billion in annual retail sales in 2022. Law enforcement has been notified and an internal investigation is ongoing. Coca-Cola did not identify the ransomware group or confirm any breach of corporate or consumer data. The incident follows a wave of cyber attacks on food and beverage companies globally, including Japanese brewer Sapporo, Japan's largest refrigerated logistics company, Russian dairy producers, grocery distributor United Natural Foods, and South Africa's largest chicken producer. Compliance action. Food production facilities should review incident response plans, verify offline backups, and test recovery procedures. File regulatory disclosures within required timeframes. Preserve forensic evidence for law enforcement and regulatory investigations. Source: The Record. Next section, policy changes. Supreme Court blocks Trump birthright citizenship. Order: The Supreme Court blocked enforcement of President Trump's executive order attempting to narrow access to birthright citizenship, with 5 justices finding it violates the 14th Amendment Citizenship Clause and Justice Kavanaugh concluding it violates federal law. Justices Thomas and Gorsuch dissented in a 91-page opinion arguing the majority devalues constitutional citizenship and claiming the 14th Amendment's subject to the jurisdiction language requires parental domicile in the United States. Thomas defined citizenship around the concept of being American, which he described as having no other homeland and no allegiance to any foreign power, tying citizenship to military service and ideological loyalty. The majority rejected this interpretation as inconsistent with constitutional text and the 14th Amendment's history. Source: Scotto S. blog. Trump declassifies 2020 election documents showing Russian interference. The Trump administration declassified intelligence assessments from 2020 intended to blame China for election interference. But the documents show Russia conducted election manipulation, while China deliberately avoided interfering. The National Intelligence Council assessment states Putin intended to support Trump and harm Biden, while China preferred Biden but took at least some low-level, exploratory steps, and probably have not included the use of Beijing's most aggressive options to avoid backlash. The documents reveal Russian operatives spread false rumors about Joe Biden and Ukraine targeting Trump White House officials. A comparative chart shows only Russia, not China, sought to manipulate election processes by targeting, accessing, or manipulating election processes or election-related systems. China took preliminary steps, but no actual attacks were observed. The declassification occurred as Trump delivered a primetime address undermining trust in the 2026 midterm elections. Sources: TechDirt. Next section, compliance takeaways. Review any municipal surveillance contracts with flock safety or acoustic gunshot detection vendors for compliance with state wiretap laws and verify what non-gunshot sounds trigger law enforcement dispatch. Audit COPPA compliance if operating apps with users under 13, including age verification, parental consent workflows, data minimization, and retention policies for deleted minor accounts. Preserve ISB fee structure documentation despite FCC rule rollback, as state consumer protection laws may still require fee disclosure and prohibit deceptive pricing. Food production and beverage facilities should test ransomware incident response plans, verify offline backups exist, and review regulatory disclosure timelines for cyber incidents. Subscription services must disclose all feature paywalls and additional purchase requirements before consumers complete payment to avoid deceptive advertising claims under state consumer protection laws. That concludes today's legal and privacy brief. From Carolina, Clear Tech. For informational purposes only, not legal advice.